In our previous episode of Market Journal, we discussed how 3 bills before the Nebraska legislature could aid livestock expansion in this state. One measure, LB 176, could increase pork production. As we've said, Nebraska ranks 7th in the nation in commercial hog slaughter. While it has increased production, a 2013 report from UNL's Department of Ag Economics showed it hadn't scaled up as quickly as its neighbors. From 2003 to 2012, Iowa increased its inventory of market hogs by nearly 32%. Indiana added 26%, Minnesota 20%, Kansas 17%, and Illinois 15%. Nebraska only grew by 3%. Because the livestock and crop industries are enormously connected in this state, that slow pace can also affect corn and soybean producers. The same UNL report showed nearly 80% of Nebraska's soybean meal was being moved out of state for use. While LB 176 could help increase Nebraska's role in the U.S. pork industry, Nebraska Extension Ag Law Specialist Dave Aiken says other states with similar measures have added extra provisions to further protect producers.
Well, LB 176 would authorize custom feeding between meat packers and Nebraska livestock producers. For a long time in Nebraska, that had been outlawed by Initiative 300 of the corporate farming law, and also it's also been outlined by statute, so that existing statute would be modified by LB 176 to authorize this for the first time in a long time.
Tell me how the contracts would be regulated.
Well, there is federal law, the so-called GIPSA rule that USDA implements, which has some basic kind of fairness requirements for these, but I don't think they go as far as they need to protect producers and these types of things, because the producers, the packers are big, have all the lawyers, give them a 50-page contract that I couldn't understand, and say sign it or take it or leave it, and that's it. At least that's been the experience of the poultry industry. And so dealing with those kinds of abuses are kind of what these concerns are about here.
So you say these GIPSA rules, they deal primarily with 3 things. The first is contract cancellation, the second is capital investment disclosure, and the third is dispute resolution. Let's talk about those individually and if they go far enough. The first is contract cancellation provisions. Tell me about that.
Well, the GIPSA rules give producers 3 days to walk away from the deal after they've signed it, and that's a good first step. But most of these contracts have confidentiality requirements that say that you can't tell anybody what's in this because this is all a trade secret. So they can't take it to the lawyer and say, is this good or bad for me? They can't take it to their accountant, say, is this going to work for me financially? And so a lot of states have gone beyond this and said, no, you have to be able to show this to your business partners, your family, and your advisors.
So states have determined that this doesn't go far enough.
That's right. Several states have.
Okay, let's talk about the second one, capital investment disclosures.
Well, this again, the GIPSA rules require that if the producer is going to have to make a capital investment of $12,500 or more, that has to be disclosed up front and prominently, so that when the producer signs it, and originally when they sign it, they didn't get a chance to review it. They would then realize that they were going to have to find the money to build whatever it was they're going to have to build to be able to implement the contract.
So did that offer enough protection for producers?
Well, again, some states don't think so, because producers, the issue is that if the contract is canceled, say halfway in, and you still got this big loan on this farrowing house or this swine facility that you haven't paid for yet, you could be in a pretty bad way. It'd be worse if you're in the poultry industry, because if you don't have a contract to sell your birds, you can't sell them anywhere. In the swine market, the market is better for the producers, so they would have some options, but it would still hurt.
All right, the third angle of this is the dispute resolution. Tell me about that.
Well, a lot of these things are set up with arbitration clauses saying that if we have any disagreements about what this contract means, we will settle it through binding arbitration, and the packer gets to appoint who the arbitrator is. A lot of times they may even be employees. And this is pretty one-sided. And so what some states have done is said, no, if you're going to do this, either let them go to court or take it to mediation, where the mediator is not a lawyer, no lawyers involved in the process at all, and they try to come up with a win-win rather than just which technicality wins.
So states have gone beyond these GIPSA rules then?
That's right. Several states have. They started in the southeast, but there are several states in the Corn Belt that have as well. And those states include like Iowa, Kansas, Minnesota, Wisconsin, Arkansas, and Georgia.
Tell me what some of those common producer protection clauses include.
Well, they have requirements that the contract be understandable, that it be written in basically junior high school level complexity, and that all the financial risks to the producer are clearly disclosed up front. Give the producers the first lien ahead of the packers' creditors in terms of payment, so that if there's not enough money, the producer gets paid first. And then prohibiting retaliation if producers do things to try to, enhance their own economic standing or join with other producers and associations, something like that.
So you mentioned that these other states have already done it. If Nebraska were to pass 176, what would be the route that Nebraska would go to also ensure these protections?
Well, if 176 were passed today, the gypsum protections would be there, but as we've discussed, I don't think they go far enough. We would need to either amend 176 or pass a separate new LB to, get some of these things added into and make it part of Nebraska law as well.